peut continuer à suivre sa débat informel, le code civil. Avant nous de quitter pour nous break pour des années, nous pour retourner, nous pour prendre sa section qui s'appelle guardianship. Et professeur Angelo finit dit pour dire n'a pas grand changement en search là-dedans. Mon imagine qu'il faut une sens pendant ce lunchtime pour regarder. S'il n'y a aucune clarification, aucune query, on va prendre. Après, on va move to book 2. So very good afternoon to you all. And we will start with guardianship, and then we'll move to book 2. Honorable Arisol.
Thank you, Mr. Speaker. Good afternoon to everyone. Mr. Speaker, in regards to guardianship, under Article 433, Sorry, good afternoon to everyone. Mr. Speaker, in regards to guardianship, I want to focus on Article 433. Just a small clarification in regards to a person aged 65 or over may refuse to act as guardian. 433.2, if appointed before that age, the person may continue until he or she reaches the age of 70, or he or she may ask the court for release at the age of 65. So my question is, why 65 and 70? Since Seychelles, the retirement age is 63. Why 65? Thank you very much.
Okay. Thank you. Honorable Wawo. John Wawo. Honorable John Wawo.
Good afternoon, Mr. Speaker. Good afternoon, the panel, and everybody else. Also, with respect to 433, in a case where both guardians are over the age of 65 and they relinquish their guardianship over a minor, what does the law provides for the legal requirements for the minor?
Okay, thank you, Honorable John Wawo. Professor, you want to tackle this too? Yes.
I can deal readily with the first question. The answer is no change. So whether 65 should be altered is a matter for the Assembly. This is a provision which has not changed. So the committee expressed no view about the particular age. So if it is inconsistent with modern practice, then there is no reason not to change it. The reason that it is there is simply reproducing the existing law.
Okay. And the second.
I'm looking for the exact provision, but the general principle is that the court can always appoint a guardian. So the child will not be without a guardian.
Okay. I don't know, Professor, maybe the 65 years, is that because of retirement age, maybe elsewhere in France or UK? Because I think in UK 65 is a retirement age.
Yes.
I'm not sure about France.
Yes. It is, from memory, the French one has recently changed. But this is a standard age for retirement. And it's clearly been that since 1975. What it was previously, I can't immediately tell you, but there is no doubt that life expectancy has changed dramatically since 1975. So on actuarial base, you might expect that what was proper retirement age in 1975 being 65 might now be later. But I think there is no magic in the number. It is historical remnant, and whether the Assembly would think that should subsist, or whether a younger or later age would be more appropriate. That is for the Assembly. 433, where they can retire. His question was why 65?
Thank you, Professor. Honorable Basil Wao. Could a mic somewhere?
Good afternoon, everyone. Thank you, Mr. Chair. Mr. Chair, I have a number of issues. Article 392. Presently worded, the proposed amendment is a guardian or minor may be appointed by a parent who is a guardian. Okay, by a parent who is a guardian, by will or by declaration. Now, the present wording does not sufficiently address the issue where you have two parents, where both are guardians. Because you might have a conflict whereby one parent will say, this provision allows me on my own, I am a guardian, and I can go and appoint another guardian. The mother can say that, and the father can also say, I'm going to appoint another one. So there might be a conflict which might arise here. This is why I believe the wording under Article 397, presently, the present Article 397, is better. It prevents such a conflict from arising, because it says a guardian appointed, this is about when it's appointed, it says a guardian appointed by the parents or the survivor of them. So I believe the wording should be a guardian may be appointed by the parents or the survivor of them. So which will make it clear that when you have two, you have two parents and both of them are guardians, then you need the consent of both of them. But in the case whereby you have only one of a survivor, then that one can appoint. Because there might be a conflict. You might have a conflict because right now the way it reads, a parent can say, I'm going to appoint X. The mother can say that, and the father will say, no, I want to appoint Y. So in order to prevent that, I believe we have to be clearer to prevent this conflict from arising.
Although, don't you think that all this is saying is a person who can appoint a guardian?
Take the mic.
Sorry. Don't you think that basically, I agree with you entirely. You're right. But don't you think that what this is saying is a person who can appoint?
Mike, put it on, please.
Hello? Don't you think that what this is saying is a person who wishes to appoint a guardian can do so by will or by declaration? Essentially, that's what this is, procedural rather than substantive. That's how I read it. I may be wrong, but substantively you're right.
I can see your point, Honorable George, but I believe that hasn't been translated in that in the present wording. It is both substantive for me and procedural, and I believe to avoid any ambiguity, any conflict in the future, or misinterpretation, we should be clearer. Just yeah. Okay. Then Article 401. When I look at Article 401, 401 bracket 1, when I read this provision on its own, it gives the impression that a guardian has a discretion whether or not to accept the guardianship. So it gives the impression that the guardian has every right to say, I'm not going to accept it. Okay? But when I go now to to Article 439. Okay, 439. It gives a different impression. It conveys a different message because it says a guardian who does not want to accept appointment shall communicate to the court the reasons for the refusal. So if I have absolute discretion as to whether or not to accept, why should I go to the court and tell the court the reason? So when I look at 4391, it gives the impression that the court will decide whether or not to relinquish me of my obligation under the guardianship. And that's why I will go back now to the present code. And I believe 4391 is the right approach, proper approach. Because I believe we should go back to the wording of 401 of the present code, which provides that if the guardian who is appointed does not wish to act, the court shall have authority either to compel him to act or to appoint another one. So the court has authority to compel him to act. So what I'm saying is that I believe the court should still have a discretion. If a guardian provides unreasonable grounds as to why he does not want to act, then the court should say, no, I will compel you to act. I think that we should, and that idea is conveyed a bit in 439.
My recollection of the committee's discussion of that was that in the present environment it would not be helpful to have as the guardian of a child somebody who didn't want to do it, given the obligations that are cast on a guardian, and that the situation was now quite different from the days of the origin of that provision, where there was a conseil de famille, and that was a public duty on the members of the conseil. So you're right, the committee did address that and said, what is the good for the child if the person who is supposed to be looking after them, managing property and so on, doesn't want to do it? So that is why that change. Whether it's appropriate is another question.
Okay.
Okay, it's a policy decision at the end of the day. But then if that is a policy decision, then we should do away with 439. Because if he has the right to not to accept, then there is no necessity for him to go to court and provide reasons as to why he's not accepting the guardianship. So that's, the next point is,
There are other guardians than those appointed by the mother and father.
Yes. In fact, this is a very interesting point, and it's not one which had exercised my mind. But now that Honourable Wawaz raised it, I think we need to, we need to focus on it as an assembly. You see, how will the issue arise? You will either be appointed guardian by a parent who has sought your consent first. Okay, I want to appoint you as guardian of my child because I am living on Praslin, and the child is coming to school on Mahe, and I want you to be the guardian. And you will say, yes, okay, fine, appoint me, and they'll go before a notary and do a declaration, appointment of guardian, and it'll be done. Or you will certainly find out when your sister has died that she has appointed you as guardian of her minor children under the will, without having consulted you necessarily. In which case, and you might say, well, no, I don't want to be appointed guardian. So how would you renounce that guardianship? I think perhaps the two provisions have to be read together, because the only way you would renounce it, if it's not a renunciation prior to appointment by saying I don't want to be appointed, would be that you'd go to the court and say, I've been appointed under a will, I don't want to discharge my function, so please relieve me. And if that is the case, then the two provisions don't clash.
I understand where Honorable George is coming from, but in that case, it's about renunciation. Then the only provision we should include is not to provide reasons, but simply to go to court and say, I don't want to accept that responsibility. So instead of saying provide, because when you say you have to provide reasons, then it's as if a court will have to determine whether there are good reasons to remove you of your responsibility of as a guardian. The other one, 384. 384 is regarding administration of properties of minors. We've said that in the case of a divorce, and we have proposed that in the case of the end of a termination of a common law relationship, that right of the administrator will be the parent who has custody. Should we not consider the same thing in respect of guardianship? That in the case of a divorce, then it should go to the, or termination of a common law relationship, it should go to the parent with custody, who has custody of the child. That is something I'm just proposing.
Yeah.
So again, a policy decision for us to decide.
Yes. That was,
And that might be consistent with 384.
yes.
Word. From Article 1476, we use the word word. We all know what it means, but we start with minor and then move to the word word. Should you not then define what is a word? Is it defined?
Yes, in Article 3, right at the beginning. Yes, back to the common law pattern. Yeah.
Okay. 417. 417, Professor.
Yes.
Sub-article 2. That is in respect of the way it's worded. If a ward resident outside Seychelles has property in Seychelles, at the request of the interested parties, the court may appoint a co-guardian. Was it the intention that the co-guardian would be somebody domiciled in Seychelles, or it could be somebody outside of Seychelles?
Here.
Then we should say so, because it doesn't convey that.
Right.
But, yeah, domiciled in Seychelles. 4351A. I know it's taken from the existing 442 of the current civil code. But we say that the foreign persons must not be guardians, minors except their own child. I know this is borrowed or taken from the existing code. But if you're a minor, you cannot be a guardian. On what basis can we justify that that person can be a guardian of his or her own child? Because we say you are incompetent. You cannot take decisions in respect of a minor. Why should it be different simply because it's your own child? I think that is something we need to consider. We need to be consistent. Yes, but, but you cannot even protect the interests of your own child. This is something for us to consider, to ponder on.
Go on.
Can a minor, well, the rights of minors, can a minor sign on behalf of another minor? No.
But it seems for your own child you can.
For your own child you can?
Yeah. This is what we're saying. We should not be there.
Yeah. I mean, I see the logic and it makes sense.
For the minor to sign.
No,
No, exactly.
No.
no. Because even though it's your child, you're still a minor.
Exactly.
You're under guardianship.
A minor who has a child,
And who's the guardian?
the child of the minor shall be, the guardian of the child of the minor shall be the same person as the guardian of the
Child.
minor. Who has, is the parent.
So what are we saying? Yeah, are there any,
This is the existing law.
Existing law.
that's the existing one?
I think we should do away with it altogether.
There is another aspect to this. relating to earlier debates, which was that a minor might be able to marry. Do you remember? Yes. So, but if in that circumstance you would have a person under 18 who is married, who would then have extra capacities. And that's the old provision. This may relate to that, the existence of that.
But given that that we have
Yes.
rejected the marriage of minors, then I think we should also delete this one.
No, 4351A.
Delete the part except for. Okay, shall we?
Yes. And when I'm looking at Article 447, and this is dealing with the removal of the guardian. What we have Article 445 of the present code, Professor.
Yes.
I don't see where it's been incorporated in the proposed code. Article 445 is very clear. Any interested party or the Attorney General may start proceeding for the removal. This is specific to an incompetent or dishonest guardian, but I believe we can apply it to general removal of a guardian, but say clearly that any interested party or the Attorney General may do so. Because there is nothing there. I know under Article 403 there is a provision for the intervention of the Attorney General, for the Attorney General to intervene. But that is to intervene in a proceeding which has already commenced.
Or in 4392.
4392. Yes, exactly. To intervene only, but to start, to commence. I believe we should include that provision of Article 445, but right now it's specific to whether minor is incompetent or dishonest, but we should have it for general removal and appointment of guardians. Any person interested or the Attorney General. Sorry.
What about 4442?
4443.
This is the old rule of the Ministère Public.
It's the same as, but again, it's restricted to incompetent and dishonest guardian. It should be general.
Removal of the guardian.
And so,
Let's carry on now.
and I just want to make a comment, a general comment regarding Article 470, which actually it's been there in the code, and I have to be honest, it's something I have never paid attention to. And I'm wondering how many guardians are doing that, discharging that responsibility of filing to the Register of the Court annual statement of account of his or her management. I'm wondering.
But
And actually, to be frank, I've never addressed my mind to that. And I think it's something which guardians should be aware of and they should comply with.
the committee was of the view that it was relevant and
No,
important.
it is. I understand why it's very.
Okay, thank you, Honorable Wao. Any more queries with regards to guardianship? Yes, Honorable Henry.
I just want Honorable Wao to go back to his objection on 4391. Let's say can we have a scenario where parents have separated? So say the mother is living on Palin, the dad is living on Mai, but the dad has never acknowledged the children per se. So the mother is dying, but want the dad to be the custodian, the guardian. But because of the dad, how he is, he doesn't want to take responsibility. So in that case, because he's the biological father, so the mother wants him to take responsibility, to be the guardian. So if he refuses, based on the article 401, right? So shouldn't he be then compelled by the court to give plausible answer why he wants to refuse based on 439?
Well, Honorable Henry, I understand where you're coming from, but I believe what you said is a policy decision for us to decide whether we're going to compel such person to give reasons as to why he or she doesn't want to take the responsibility of guardianship, or to simply to say, I'm going to renounce. It's a policy decision, but it seems from that the committee took a policy decision that the person will have absolute discretion as to whether or not to accept guardianship. So when as an assembly, we have to decide upon that.
Yes, Honorable.
Because in that case, we also have to take consideration the welfare of the child. I mean,
Yes.
I'm sure this is
Basic principle.
yeah.
It's first important. Yes.
Because if the guy, even though he's a biological father, is a drunkard or he's been to jail a couple of times for interfering with minors, even though he's the biological father, he's just unfit to do so. So,
Yes.
yeah.
Thank you. Honorable Aglai.
I just want some clarity in regards to guardianship. When you're talking about guardianship, and to what extent do you qualify a guardianship compared to adoption? Because maybe there's some people that is confused also when you're taking a minor under your guardianship, and like we say in Seychelles, we're not talking when we take someone on, we say, I have adopted this one, but we are not qualifying as guardianship. What's the difference? How will you qualify these two?
Okay, thank you, Honorable. Honorable George.
Thank you, Mr. Chair. I think Honorable Aglai has asked a very, very important question in our context. You see, there are a whole series of relationships that people can have with children. You can be a parent and also have custody of your child and also be the guardian of your child at the same time. You can be a parent of the child and custody of the child be with somebody else, like for instance when the parents have separated. One can be the parent, but the custody, which is the daily care and control, is given to somebody else. And the guardianship, which is the legal control, so the administration of the affairs of the which school to go to, what to do with the money in the bank, etc., that belongs to that child, that is what a guardian does. And then, of course, in Seychelles, we have the fostering, which is not legal fostering, it's kind of a social fostering, petit soignen, where you take the child under your wing and look after the child. That has none of the above. The child is in your custody without you having custody of the child legally, without you being a guardian legally, etc. You're just looking after the child, rendering a social service. And then, of course, there's adoption, where the child becomes yours, as if you are the biological parent. So you have exactly the same rights as you would have had as a biological parent. But I think the important thing is the three. Custody, which is physical control, guardianship, which is legal control, and then, of course, parenthood. Okay? Those are, I think, the three things that we need to know that they can be in three separate people at the same time.
Okay, thank you, Honorable George. Honorable William.
Thank you, Mr. Chair. Mr. Chair, I want some clarity regards to guardianship in relation to our words. and minors. For example, I would like to know, I mean, if present laws, existing laws, facilitates the graduation of a ward or minor attaining the age of 18 to take decisions, so, I mean, dispensing of the guardianship. Because, I mean, for example, in terms of Article 449 that Honorable Wawo was referring to with regards to assets. And, I mean, fight for the accounts. So at what point in time does the ward end? Yeah. Can the ward, I mean, go into the processes of the court process?
You want to tackle this, Honorable George?
Yes. Guardianship applies to two categories of people: minors, so 0 to 18, and then people who are interdicted. Adults who are habitually feeble-minded or incapable of looking after their own affairs, mostly their own financial affairs. You might have somebody who is not confined to a psychiatric unit, but who is not capable of looking after their affairs, but they might have money. In fact, if they're over 65, over 63, they will have some money coming in every month from the Social Security Fund. So you can interdict them. And interdiction is a process where you take that person to court and get the court to turn that person, as it were, into a minor and appoint a guardian to that person, so that that guardian looks after the person's interests in exactly the same way as you look after a minor's interests. Now, guardianship of minors ends with the minor coming of age. Guardianship of an interdicted person ends with the court making an order. Unless the interdicted person dies, of course, the court may make an order because the person may come back to his or her senses and be able to manage their affairs, in which case they can apply to the court to get the order lifted, in which case the guardianship will come to an end and they'll be able to take their affairs. And Honorable Wawo's point earlier is very important. During the guardianship, you've got to have kept good accounts and handed them over every year, so that somebody can check them to see that you're not actually taking the money of your ward without their permission.
Okay, thank you, Honorable George. Okay, we will now move to the next section. Okay, we will move to Book 2, Property. Yeah?
Interdiction. Can you,
Spendthrifts?
yeah, give the professor just give
Please,
a short
Professor,
synopsis
go
of
on.
what interdiction is.
Yes.
489.
This is 489. This is a modernizing of the present, modernizing of the statement of the present principles, which include some interesting, where are we? The provision for instance, spendthrifts, and as Honourable George has said, people who are adults who, for some reason, mental illness or otherwise, are incapable of looking after their own interests. So the basic principles are set out in 489. 490 says who may begin, what is the procedure for establishing the guardian of an adult. So you're actually, as has been indicated, depriving them. that person of their capacity as an adult to look after their own affairs, and by and large, the procedures or the obligations of that guardian are the same as for the guardian of a minor. And you have 510 has the purpose clause, if you like, that a role of the guardian is to use the property of the ward to improve the condition of that person and assist their early recovery. So it's not just manage, but assist. And then the conclusion, in the case of a minor, it ends on achieving majority, and in this case, it ends when the reason for the controls has passed. So the person recovers good mental health, then the interdiction will end, the guardianship will end.
Thank you, Professor. Okay, Honorable Wao.
I know this is supposed to replace to a certain extent wider than Article 513 of Present Civil Code. But my issue is the wording. Does it actually cover spendthrifts? Sorry. Because when I look at 5489, it says an adult who the court is satisfied requires supervision in respect of financial matters may be made subject to a supervision order. Does it convey that it will include a spendthrift? Because the spendthrift can tell you, look, I don't need supervision regarding my financial matters. I know what I'm doing. I'm spending my money because I want to spend it. This is my intention. Whereas before, I mean, under 513, it was clear because you wanted, it was clear, it was spendthrift is actually mentioned. Maybe forbidden to engage in litigation to compromise legal rights, to borrow, to receive any capital, and so forth. So, I know we wanted to, probably the intention was to make it wide enough to cover other circumstances. If I propose another, including spendthrifts, who the court is satisfied, at least to make sure, because I don't think it is caught present in the wording of 4892. There is room for somebody to argue legally that it does not cover spendthrift.
And paragraph 1 doesn't do it, that they're not looking after their own interests, nor are they able now to fulfill their family obligations.
No. I think we're looking now about interdiction, this one. It's more 481 is about interdiction, this one is to control the spending, maybe, but it's not clear.
Yes, Honorable George.
This is one that I remember specifically.
Yes.
In fact, we thought that the word spendthrift was very Victorian and had no. It's a bit like rogue and vagabond under the penal code.
Yeah.
There are things which existed in the London of Dickens, but which in the Seychelles of today, we thought the word itself we thought was not modern enough. So we tried to capture the idea in an extended definition. We didn't want to do away with it, and we fully understand that there are people who
Spendthrifts.
who are spendthrifts, who are compulsive spenders, and you've got to protect them against themselves, which is what interdiction is all about.
I think the code, I'm just looking at, it's okay.
It's okay?
I was making a statement.
All right. We can now move to. Yes, Honorable Espoir.
Speaker, going back to 489, if someone has been appointed legal guardian, how long does that exist? How long will that go? How far? Let's say I have been appointed as a legal guardian to my brother who has some mental problem, and then he recovers from it. Can this be stopped, or how long can it go?
Okay.
511,
Sorry?
511 article. When the
511.
problem
511.
Okay. My next point is, as mentioned earlier by the leader of the opposition, I am 16. I've given birth to a baby. I am the legal guardian of my baby. So, I should be the legal guardian of my baby because I am not, I am the mother. Yet I'm not 18 yet. Who would be my legal guardian? Is it my mother? I'm consenting for my child to have the immunization. Who will consent for me to have contraceptive?
Yes, Honorable Ron.
But in fact, now that the point has been raised again, I'm thinking of the issuance of a passport, where, well, as it stands now, but we've said to remove it. So if a young mother wants, but the young mother cannot have a passport without her guardian, without her guardian applying for it.
Passport, no. Under the Passport Act, it's different. A parent can.
Parent or guardian.
A parent, guardian, or two parents, they can apply for a passport under the Passport Act.
Even if they are minors?
No, minors, yes.
Okay.
Where the parent is a minor.
But when the parent is minor, is a parent. Because you have, nowadays we have a minor emancipé. So he has been emancipated by, either by marriage or, you know. Yeah, but this is child. Non, mais Passport Act is un parent.
Yes, but
It has to be clear.
yes, but again.
Parent adult.
Yes, because again, I think if we are in the process of clarifying matters, I think all these things need to be clarified. Because if again we want that to be what the exercise that we're doing, we want it to be our code. We've said minors cannot get married, okay, and probably other countries will, but this is our code. So if we're talking of minors and issuance of a passport, I mean, I think it should be. I mean, I think we're looking at an adult being able to sign on behalf of a minor.
But then
I
the
don't-
guardian, because the Passport Act says a parent. Now, if the code says a minor cannot be the guardian of his or her
Then it
own
falls.
child, then there should be this Passport Act should be included as one of the consequence enactment to ensure that where the parent is a minor, then it will be only the guardian who will be able to apply for a passport for the child. So exactly like what Abba was saying with regard to immovable property, it should be stated in there. Because the problem with the Passport Act is that any parent can go and apply for a passport for the child. This is one act, in fact, which is a legal act, but any parent can, not a guardian.
Yeah, so, yeah, I agree with the Attorney General.
18 ans montant.
Yeah.
D'un passeport.
Yes.
D'un passeport. T'as petit parent qui est miné. Ou vient
Well,
par.
this is what, but a parent is a parent.
Yes.
I mean, a 15-year-old then can sign for her 10-year-old to.
Oui,
For
mais ça-
her 3-year-old, sorry. For her 1-year-old. I mean, I think we should go lower for a 6-month-old to have a passport, which does not make sense. It just does not make sense because on the other hand, the 17-year-old who is doing his or her A-levels, who is educated and Honorable Wao's daughter who came out
Cannot
with
sign
flying
for a passport.
colors cannot sign for a passport, but this 16-year-old
I think in the context
because
of
she's a parent
passport,
does not make sense.
what they mean
Does
by
not make
parents, they mean parents, 18, adult parents, but it's not specified in the act. It says parents, but I think it's.
This is where we should use the expression guardian. Guardian. Because it's a guardian who represents somebody in a legal act. Not a parent.
Honorable.
The issue raised by Honorable Alcendo, access to contraceptive by minors. This is an issue which we have to address. And this is an issue that healthcare workers, nurses and doctors, they are asking questions also about. And we have to give an answer to that. I believe that the age of consent in Seychelles is 15 years old. Okay? The age of consent.
For sex.
Yes. The age of consent. Yeah, it is. 15.
For sex, yes.
Yeah, for sex, yes.
But not for contraceptives.
No, yes, exactly, for sex. The age of consent is 15 years old. Now, if that is the case, then our law, civil law, should provide that a minor, 15 years of age, should have access without having to go through his or her parents.
Absolutely.
Because if we cannot be hypocritical telling the minor, look, you can, there is no offense committed by a person who has sex with a minor who is 15 years old. But yet you're telling a minor, for you to get access to contraceptive, you have to go through your guardian. That cannot be so. So I believe we have to be consistent, both in the civil aspect of our law and in the criminal aspect.
Okay, thank you. Honorable William.
Yeah, Mr. Chair, in relation to what Honorable Espama has said, I don't want to complicate matters, but in the present, revision of the civil code that we have already accepted that under the age of 18, who is married, is accepted as an adult.
Sorry?
Yes?
No, we've done away. Remove that.
Under 18, nobody can get
Yeah.
married.
Yeah, exactly. We have to bring consistency. Honorable George? Yes.
I know what the answer to this question is going to be, but I think it needs to be raised. In that case, should we not say that a minor who has had a child is an adult, i.e., define it in 17? Yesterday it was, if you were married, you would be an adult immediately. As I said, I know what the answer is, but I think we need to address it, if only to reject it, because it is a question that begs itself. You emancipate the child upon the child giving birth to another child. So what is more adult? What is a greater proof of adulthood than giving birth?
Giving birth is not a sign of
No, I think we're trying in the long run. We're trying to put order in the society.
I totally agree. So we pick an arbitrary date, which is 18, and we turn a person who might be totally irresponsible into an adult just by attaining 18, and yet somebody who has given birth and who looks after a child but who's not 18 yet is not an adult. Isn't that an anomaly? I know the answer, but I think the question needs to be asked,
Okay.
and we need to ponder over it.
We had a situation where the girl became a mother at the age of 10. What do we do with this one?
Becomes an adult.
Oh,
And what about the father?
What about the father?
yeah, the father was not 10 years old, no? She was 10, the father was not 10.
Well, if nature intended women and men to reach adulthood at the same time, why did nature make women become? Why did nature get women to attain maturity earlier than men? One size fits all doesn't always work.
No, but in fact it was part of the responsibility given to men to take care of the woman. I might be shocked for saying that, but it's okay.
But in so doing, abuse and everything. Okay, shall we? I think we've taken the notes now.
Yes.
Okay, shall we move to book 2?
But are we agreed?
Yeah, we've taken notes, and I'm sure that will come on. Yeah. Okay. Yeah, let's move to book 2, articles 516 to 710, property and the different kinds of ownership.
Thank you. Would you like me to?
Yes, please, Professor, guide us.
Yes. This book is relatively short, around 200 articles. This deals with, with property matters, and the principles are basically continued. There is the same pattern of modernizing the language and breaking up the articles in accordance with modern drafting patterns. There are, I believe, fewer matters that will cause great difference of opinion because there are not very many which have a strong moral aspect to them. I bring perhaps 4 matters to the members' attention. The first one is not a change. There is a large definitional area really setting classification of property, what is property, what are the different kinds, and the consequences. It's like a taxonomy or a dictionary. Then the matters which are continued, the question of usufruct, use and occupation, and easements are effectively unchanged, but there are 3 areas that the members may wish to focus on. The first is the domaine public. Domaine public is in the existing law, but bits of it only. We're starting at 516 to 710, and domaine public is the first where there is change, is covered by 538 to 541. It's a change in the sense that the committee believed that all the relevant provisions should come together. Should come together and be consistent. At the moment, I think there are 6 or more statutes which in some way or other all deal with aspects of the domaine public. So the attempt here is first to identify the domain public, which is not, it's assumed in the present code, and then to give some key features of it within the code. The other principles I note here, there is Town and Country Planning Act, which has matters relating to domain public. There's a coast reserves and foreshores leases, rights of access to islands, the Road Act, and the delineation and classification of the Domain Public Act. All of those, mostly quite small, have little bits, but there is no basic picture of it. So the proposal is not to make big change, but at least to define and give the clear characteristics of domain public in 538 to 541. The second is something, or the next two are not in the code. These are matters where the courts have responded to community needs, and the committee has proposed bringing them into the code. This is droit de superficie, for instance, in 554, an important matter. And it was thought, where there are elements of doubt about the extent of the droit de superficie, that it was much better to set down principles rather than wait on a case-by-case basis for all the elements to be worked out. And the third is 556, which is relating to encroachment, which I'm told is rather more recent phenomenon, and this is where a building and some in the heart of Victoria are built, and they're a few centimeters across the boundary. This has in the past been considered perhaps as an abus de droit, but the committee thought that this particular type of activity was sufficiently distinct to warrant a clause of its own, and you'll see there when the discussion gets to it that there are a number of provisions basically about the consequences. Was the encroachment in bad faith? Were you trying to get someone else's property? Was it by accident, in good faith? Perhaps the survey marks were not accurate. Or was there connivance, so to speak, by the owner of the property who watches the building go up, says nothing, and then vindictively says, ha 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 ha, you're on my property, demolish it. So those three possibilities are elaborated in 556, and this is a distilling, if you like, of the present case law. So there are those three areas which are different, and the rest, the wording perhaps has changed, but the core principles of the code on types of property remain unchanged.
Thank you, Professor. We will start digesting. Anyway, I'll let Honorable Woodcock first, and then I have something also.
Okay, my question is in reference to domain public, Article 538.2. De salatie qui donne la liste du bon domaine public. L'article 638 DF the land which is alternately covered and uncovered by the sea at the highest and lowest tides, sandbanks, beaches, and beaches which have been gained from the sea and left permanently high and dry. Clairement, il fait référence à lance qui tombe dans le domaine public, mais elle concerne qui nous en a, qui est élevé par plusieurs membres publics, et regarding lance qui pour gagner accès avec sa lance ou besoin accéder à travers propriété privée. So pour être dans l'article 638 4, it's where land that is domain public is not accessible from a public road, the state shall, as the case may be, provide a sufficient right of way over state land to follow, to allow public enjoyment at the domain public in accordance with the law. Dans sa civil code, moi, il fait provision pour l'État donner right of way, law state land. But what about la terre privée? À cause nous avons circonstances aujourd'hui, par comparaison, les Moria. Les Moria, ils pensent un peu donner accès avec tout le monde public qui a envie arrive côté leurs Josette. Mais qui provision peut gagner fait de ça pour faire ci, qui s'est renforcé, qui bande propriété privée, qui peut pour qui indique qui a accès avec ça dans le domaine public, pareil, pas ça côté concerne là, mais c'est pas bon going, et les autres endroits qui sont dans le domaine public public pas avec accès avec à cause d'une propriété privée qui bat en plus accès avec ça. So qui nous peut faire provision dans la loi pour faire qui ça renforcer it's enforced qui dit moun should all public should have access to public domain irrelevant if it is being blocked by a private property. Okay, bless you.
A very good one, Honorable Woodcock, because moi si moi tu peux un petit peu de ça c'est que si un domaine public est barré par propriété de l'État, l'État il provide access. Mais si un domaine public est barré par une propriété privée, qui solution? Honorable George.
Yeah. Merci, Mr. Speaker. Professeur avec Sarah va excuse-moi si mon cause en créole, la cause ça y a quelque chose qui touche beaucoup de monde. Déjà dans sa code, nous bougons autant qu'il nous capable dans la direction qui, aux questions de l'honorable Woodcock y aller. Gouvernement, à cause c'est le gouvernement qui permet ça la loi, l'exécutif, il garde dit, en ce qui concerne nous la terre, nous vous donnons un right of way. Il a fait à cause c'est lui qui peut proposer ça la loi. Mais il n'est pas capable de faire le base de la terre qui existait déjà. À cause, il peut interférer avec droit de propriété en bas de l'article 26. Il y en a un right to enjoyment of property. Il est capable d'une certaine façon. Il y en a une possibilité que si le gouvernement il compose les quoi la langue la terre, un ruban qui traverse une propriété privée pour mener l'audience, il est capable quelquefois à dire que this is in the public interest. Although, est-ce que it's in the public interest pour, par exemple, pour servir l'exemple que nous donnons, pour en avoir un accès à travers le Moria. Or is it in the interest of Pralinois, basically, or more importantly, bon Pralinois qui restait dans ce cas-là et dans sa area. Alors là, on a un premier problème constitutionnel. Pour nous éviter ça arriver, et aussi pour regarder devant, as opposed to derrière, nous propose B over the page. 538 4B. Quand nous dit que le gouvernement publie sur les corps à travers la loi planning et les autres la loi qui y passaient de temps en temps pour lui faire des sortes qui un access to the public domain il gagne métier. Et nous voyons ça dans beaucoup de cas. Si moi me demande, disons, mon bout de la terre ou un lance, et mon demande planning permission pour moi faire la case, le gouvernement pour mettre en condition planning qui mon garde, mon quitter accès pour le public pour le lance. Et ça pour venir à travers mon condition planning. L'esprit c'est que le gouvernement, il y a pas force sur les corps à travers B pour autant qu'il est capable à travers les autres, la loi qui existait, provides a right of way, quand un monde n'a acheté la terre sans un accès à travers son la terre pour arriver à l'Olance. Donc, et nous imaginons que this is as far qui légalement, dans un texte légal, nous capables d'aller. This is as much qui nous capables faire. Tout en reconnaissant que la loi droit de superficie pas vient avec un droit d'accès. Il donne nous un droit de jouer, et tout en nous dit ça, ou capable accès by boat, malgré que ça y a il n'y a pas une réponse qui peut satisfaire tout le monde. À cause on n'a pas un bateau et on vient dans ce projet, on va pouvoir aller, et ça nous reconnaît. Alors, ce que nous savons faire, c'est trouver une solution dans ANB, quand nous avons observé la législation et le pouvoir gouvernement qui existait, sans qu'il y ait une polémique constitutionnelle pour attirer un maximum accès to the public domain, to the beach. Tout en reconnaissant qu'il y en a une balance qui tout le temps faudrait nous jouer entre accès avec un lance et sauvegarde droit sa propriétaire, sa la terre que voit sa lance. Par exemple, si on donne accès librement pour le lance de mourir, silence qu'elle a, ok, silence des vents. Ça est déjà balancé contre l'usage qui est public pour faire avec sa lance. Si vous prenez un boombox, ou bien vous jouez au football, ok, tous les dimanches après-midi, il faut un effet l'eau propriétaire, ça la terre qui construit un business là. Donc, ça l'idée droit de superficie, domaine public, et accès à lance, il besoin un qui ne peut pas faire d'une façon sauvage, il besoin faire d'une façon well planned.
Honorable George, peut-être on mentionne les moments qui ça honneur, il apply pour construction, l'autorité, la loi est rentrée ici, ou besoin quitter accès. Mais autant qu'ils sont propriétés, ils vident, est-ce qu'il est capable de mettre un boundary wall, tasso pour tasso, est-ce qu'il est capable de mettre un fence, tasso pour tasso, il peut encore construire, mais il empêche accès pour sa lance, whatever.
L'article 26, il dit qu'on a droit à enjoy aux propriétés. Donc, on a droit à fence aux propriétés.
Et au fence access.
Fence access. Si il y a du monde présent, un public, il y a envie access, il y a emmène en cours pour dire qu'il a besoin d'accès à son domaine public. Mais où on n'a pas l'obligation pour provide un accès. En bas de la loi, on n'a pas cette obligation.
OK, thank you. Bon, pour mon cas, qui est un petit peu... Je vais donner des demandements, mais c'est on a Benista.
Sorry.
Thank you. Good afternoon, Chair. Chair, in reference to Article 541. In that instance, can Mr. Honorable George or maybe Mr. Honorable Wao can explain in a case where the property is privately owned, how can this apply? Article 541.
Okay, 541. What's
Ownerless. Yes.
Ownerless property.
Yes.
Yes, Professor? You want?
A person dies, there are no children, there is nobody within the 12th degree of relationship, so we have ownerless property. What do? The state becomes the successor, really.
In fact, there is a case right now, which I'm dealing with, of a lady who never married, who has no children, and who had no family, who lived in Italy all her life. Said she was. and she died without a will. Her only friends were the congregation in the church that she attended every Sunday in Italy. And she always told them, when I die, I have a little bit of money in my bank account in Seychelles. I would like it to come to the church. And she did nothing. There was no will. So
No owner.
so no owner, so it goes to the state. Happily, the state here has said, well, clearly, this was not, we don't need this money. The church there needs it more, so we are finding a way around it. But otherwise, it would go to the state.
Okay, thank you. I just want to add that in certain cases also where we've seen private owners owning property next to the sea, next to the beach, even if they fence their properties, they've allowed access through their properties for the public to access the domain public. We've got two extremes. We've got places where the area is fenced completely, like Honorable Georgia said, under the Constitution, it's got every right to do it, unless somebody challenges that in court. But we've seen cases also where the property is fenced, but the owner has allowed access through the property to the domain public, which is the beach. Okay, so it's actually working in Seychelles. Okay, the next one, Honorable Churchill Gill.
Yeah, Mr. Chair, if you allow, I will ask my question in Creole for the
Yes.
benefit of the people in Prague listening. Suivant la réponse qui honorable Josine donne concernant lance, si nous dans une situation côté la terre privée, je comprends. Mais seulement c'est quelque chose que nous pas comprendre, c'est la terre privée pas le lance. Si il dans montagne, gouvernement il va aller rentrer mettre 50 mètres contour. So Chabo explique nous qui ça est possible, ça l'autre pas possible, mais c'est moi tous les deux privés. Ça y est. Après deuxième, mon quoi nous pour besoin mettre là dans si ça l'endroit à côté dans l'hôtel, ça la tête pour gouvernement avant. Présent gouvernement li une liste à la terre, il vient as a private owner, despite une liste. Nous pas quoi nous devons mettre là-dedans qui si gouvernement qui own la terre avant les liste pour un business qu'on lance, il doit être obligatoire qui avant ça liste donner permission elle doit identifier qui bon pour passer par excellence qui manière les ça poser développer il pas venir issue que du monde pas excellence. So après bonne situation current nous pour dire la loi 538 B quand on a avancé un peu plus devant pour essayer des solutions qui peut arriver avec une situation aujourd'hui avant les ça venir est-ce que les ça venir nous capable pour ça ban business to task qui nous dit mon capable accès ça ban là ce qui là aujourd'hui pas accès. Merci.
Honorable Georges.
Merci, Mr. Speaker. Mon pour demander l'honorable Boiro adresse sa deuxième point, à cause d'un point constitutionnel, et mon connaît qu'il il fait un peu recherche là. Gouvernement, le existing places, if you can force them the right of way. Moi, je vais répondre à des questions, l'honorable. Et c'est liste. Les gouvernements, ils donnent une liste. Il est exactement pareil comme s'ils vendent la terre. Il n'est pas capable plus tard sans bonnes conditions. So, at the beginning, il devrait faire sa provision. S'il fait sans sa provision, it's kind of stuck. À cause, ou pas capable, unilatéralement, sans condition et bail, après qu'il te dit mon signe. Au point about contours, il rejoint un petit peu point planning permission. Gouvernement, at any point, il peut passer la loi planning ou bien la loi zoning. Et mon la tête, et même on peut lever, il dit, moi, il y a une réserve. And I'm stuck. moyennant gagner un peu de compensation avec le gouvernement ou bien faire un exchange ou whatever. So, ça c'est une réalité que nous besoin vivre avec. Mais, et moi, je suis content mentionner Mr. Chair qui parmi les gens qui peuvent écouter nous dehors là-bas, Planning Authority aussi peut écouter nous à cause de fait texte moi et moi va chercher un petit peu ça qu'ils ont dit. Ils ont dit que dans le nouveau Planning Act, Planning Authority pour un pouvoir pour faire comme une condition planning, je sais pas, mon petit fait que dire qui un accès à donné. Donc là où demande permission planning, vous êtes pour mettre ça comme une condition et pour venir dans la loi. Alors il va poser dépendre de autres planning authority, but it's actually going to be in the law qui pour un access across private property, state property des alana. À cause de ça, il est considéré comme un développement. Dans tout bonne liste, vous avez dit, département la terre, dans le gouvernement, il dit là, en fait, européen, dans toute bonne liste qu'ils ont fait for development, ils ont fait provision for access to the beach. So, ils ont mis les là-dedans. Et ils ont dit, moi, qui dans les mouillades, dans qu'est-ce que les mouillades, c'est un provision, mais ça pour, qui fait ça accès, mais ça provision plus tard, il gagne revise à cause golf course. Dans le premier procès, il n'y a pas golf course. Les gens dans l'hôtel, c'est dans sa provision, mais les autres donnent permission pour golf course, sa provision, il gagne sans à cause de pas prévoir qu'il y ait un golf course. Mais ce qui nous capable de connaître, c'est que désormais, from now on, pas pour capable un développement qui peut empêcher du monde gagner accès à un lance. En effet, mon capable de chercher avec d'autres qui dans un bon meeting public que tu gagnes faire pour un gros hôtel qui tu peux construire. M'oublier lesquels, je crois, et fois l'hôtel Emirates Captain ou something like that, mon à l'assister, et ça tient problème. Qui m'a nous accès, qui m'a public pour accès to beach. Vous allez voir, Maya et Filia, tout ça là, il laisse un endroit, donc on a accès. N'a pas de problème. Mais dans sa haine, il est pour bloquer lance complètement. Et ça développait, ça développait qui tient à danger. Mon Hesson doit, à cause de ces bases, mais tu peux dire, ça, il dit, il n'y a pas de problème. Si un Timouni a envie de faire son pique-nique, le lance captain, il a venu. Mais je peux passer. Il dit, il y a passé à travers la réception, il y a travers dans l'hôtel. Moi, je dis, avec son boombox, avec son barbecue grill, pour passer à travers la réception, ou à ce patine mazine. Mais, on croit que ça, c'est un petit peu les passés. C'est quelque chose que nous avons avec, c'est ban qui déjà gagne permission et qui n'a pas accès. Ça, there's very little qui nous capable de faire.
Ok, thank you. Honorable Boiro, vous voulez répondre?
Plus assisé lance, accès lance, pour le moment.
Yes.
Je comprends totalement que nous avons une sortie là et on supporte 100%. Je crois pour dire exactement ce que tu parles avec ça. Et je crois que ça c'est le voyage pour gagner accès que lance, nous besoin de faire. Si vous dites dans toutes circonstances, nous gagnons accès que nous lance parce que nous sommes des jolis pays avec une jolie lance, nous besoin capable enjoy ça, Mr. Chair. Un petit peu comme si de l'Assemblée là. Mais moi quoi, Mr. Chair, je suis un petit peu désagréable avec l'honorable Zozola. Je crois pour dire gouvernement, même avec l'hôtel qui finit de faire, je crois si nous la loi, il va dire bien, nous avons compel ça l'hôtel pour donner accès. À cause nous avons dit pour dire, il est nécessaire dans le contexte society, la base public interest. Et en effet, nous dit dans le civil code, nous avons access to domain public. To domaine public is in the public interest. Ça nous fait la déclaration. Fait la déclaration là qui pas existé dans nos present civil code. So, moi quoi, il pas qui met un nouveau word. Et moi qui mon basis think aloud là. C'est nous qui nous dit B nous dit la que dit provide as far as possible. Nous dit à cause nous dit the state shall as the case may be compel a private property owner as far as possible and then it was in accordance with law, a sufficient right of way to allow public enjoyment. Compel a private property owner as far as possible. I think that qualification as far as possible est couvert pour dire bégueté. Si pas possible, faire comme si vous rien pas. Pas capable côté possible. Quand tu capable d'un accès. Ou d'un dit mon accès avec l'ance. À cause par nous dire là tout le monde dans une ça dit ça dit mon qui parle de nous accès dit que pas venir disturber. Mais si moi tu capable tous les dimanches moi tu peux me faire par bateau, moi tu peux me donner balle de salance, juste pour faire les comprendre pour dire bégueté. Mon capable disturber moi aussi. Mais si vous parlez pour compromise avec moi aussi pas compromise avec vous, mais si vous parlez ou peut à cobra par nous dire. Et c'est moi aussi qui a cobra.
OK. Merci. Honorable Churchill Gill.
Mr. Speaker, moi pas convaincu que à cause golf course parti là initialement in vini, du monde pas aller pas de retard lolas. Pas acceptable. Moi quoi planning besoin ou de façon pour ça bandi mon excellence à cause ça ils ont droit. Nous pas cap. OK? Ça y est.
Non, laisse-moi arrêter là un petit coup à cause il y a un breaking news qui fait Planning Authority, dis-moi, pour répondre à ce que l'honorable Boiro fait dire, we can compel through the Planning Act. Alors, c'est un nouveau Planning Act pendant une façon pour compel. So existing. So, ça y va capable de répondre quelque fois.
OK. Ou deuxième?
Les mon nom 50 mètres contour, on dit moi comme ça pour dire ça nous besoin vivre avec à cause du gouvernement qui a levé des mètres nous pour dire nous la terre dans la réserve. Non, quand même tirer dit on a qu'est-ce que spécifique, ça veut dire pourquoi donne nous total liberté. So après mentionner on dit après le gouvernement donne une compensation. Mais tout ça bandi mon autres la terre dans 50 mètres contour qui gagne bloqué pour un peu les temps, ça ne gagne rien. Et présent, pour les temps, aujourd'hui, il dit on a qu'est-ce que spécifique. Moi, crois si nous pour tirer, nous faisons seul tirer. À cause après tout ça la terre privée, pour pas voir cause du monde son propre la terre, s'il y a envie de développer, pas capable. Et on dit loin qu'est-ce que spécifique, ça veut dire si on pas envie à prouver son caisse, donc ça du monde pas bouger, qui reste comme ça. OK?
Laisse-moi, qu'est-ce que spécifique, merci Mr. Chair, mon vol la parole. Qu'est-ce que spécifique, c'est quelque chose qui est difficile pour un État soutenir. À cause, quelquefois, on est capable de dire, nous ne pouvons pas dans nos planning permission là, ou pas là au contour 50 mètres, pas à cause ou pas là au contour 50 mètres, mais à cause quelquefois il y en a un river source ou bien quelque chose comme ça, ça, on est capable de justifier. Mais, juste pour, without that, mon corps pas. Mon corps n'a pas capable de get away avec pardon nous ou pour demander une judicial review si autres n'a pas une bonne raison je peux besoin je peux forcer dans nous mon crois c'est dans son ruling qui est fait dans caisse Talma il fait ça c'est clair.
Oui, et peut-être même qui mon crois que une doorway avec ça 50 mètres là non mais seulement il y a corner pas dit case by case à cause pas on a besoin dit il capable d'avoir quelque chose un écosystème, il est capable l'environnement, whatever.
But
yes.
Even if it's case by case, il y a une discrimination contre les habitants parlent. À cause de ça, la loi est applicable pour parler, pas applicable pour marier avec la digue. So là, il y a une discrimination. Ça policy must be done away with complètement. Mais de quoi appliquer? On a case to case basis.
Non, il y a
dit mon qui a dit.
Marié aussi, le marié aussi dans certains areas. Belhomme, par exemple, il y en a en l'air aux montagnes Belhomme, Lignol, la famille Chetty.
La réserve, mon
boundary, oui, réserve.
Pas de réserve.
Non. Mais le gouvernement, il révise sa boundary pas trop longtemps. OK, so il y en a, le gouvernement, à travers son ban la loi, il revoit boundary de temps en temps. Il y a son honorable, wow.
Ça point, Mr. Chair. Et en effet, moi, je mentionne ça aussi dans son zisme de la Kestalma. Planning, il y a une tendance pour venir dire quoi, ça mon policier. On n'a pas un policier. Si on a envie de restricter le use of land particular area, on a pour faire ce qu'on appelle development plan, Quand on a un coach planning, on fait un development planning avec publish. Ça commence après, moi, quand on arrive dans ces mains. Si on veut faire ça properly, on ne peut pas dire un policier pour dire là ou pas pour construire ça. Si vous faites un travail.
Pristine Beauty.
Exactement, si vous faites un travail ou development plan, qui va faire legal. Mais non, ok, mais je peux faire pas, il est vraiment mal ad hoc.
Merci, non, on a George.
Mr. Chair, mon cher content, partage un lot.
Breaking.
Un lot breaking. Les mauvais qui, mon tweet, il peut les mauvais qui Donald Trump.
Pas bonne fake news.
Premièrement, il y a quelque chose qui me croit, mon devrait dire Lily. Access to the beach is good to have. Ça pas sorti planning, and I'm all for that. But what about rules or code of conduct while enjoying the beach? There should be something to ensure that people behave in an orderly and respectful manner. Okay, je crois qu'il y a un très bon point. Mais breaking news is this: l'OSA 50-meter contour planning authority dit case by case is not correct. It has been done away with. The 50-meter policy has been abolished. Planning policies are introduced through land use plans after a thorough process of public consultation. That's what they tell you.
Et moi, je compte peut-être ça consensus le use of silence and all that. Access is provided, mais use of silence is fait dans toute responsabilité. Et même là, on peut couper à travers une propriété privée, un private owner qui laisse ça access, même on peut couper à travers son propriété aussi, tout besoin de faire, il y a tout respect. À cause il peut donner nous ça accès sans même qu'on ait besoin d'aller en cours pour le regarder. Ok, so je crois qu'il y a un petit peu dans responsabilité. Bon, on a plusieurs membres qui sont la liste. Moi, si nous prenons un break là, et nous allons retourner 80 ans. 80 ans, on va emmener ce petit 5 et 10 comme ça. Bon, merci.